wasn't quite sure what my brief was going to be today when Henry invited me, but what I basically want to focus on is the nature of the controls in U.S. law over the back end of the fuel cycle, which is what Frank was talking about. Contrary to what Henry said, I think our Nuclear Non-Proliferation Act, which was adopted in 1978, has a lot of clear standards and criteria in it governing what should happen at the back end of the fuel cycle. The problem, as I went back and looked at the history, is that the story is kind of a long, sad, and depressing one of what I would really characterize as a subversion of the basic intent of the NNPA with respect to controls over the back end of the fuel cycle.
By the way, in this regard and all others, we're in violent agreement. I think we mean the same thing.
And the results, at the end of the day, are really by about 1996, about 20 years into the implementation of the NNPA, is that the United States, particularly for those countries with advanced nuclear programs, was not instituting significant controls over the activities that could take place at the back end of the fuel cycle. And today, I think, to talk about the NNPA is to talk about what is pretty much a hollow husk of a law with respect to actual controls over what our partners do or don't do. At the very least, we're left with a situation which Henry described, whereas, you know, what the president says goes. And the intent of the framers of the NNPA, people like John Glenn, pretty much is honored in the breach rather than in reality. Let me start with background. Now, I confess to having worked in 1977 on one of the first efforts to uncover the nature of U.S. controls at that time, prior to the NNPA, over back-end fuel cycle activities. And until the NNPA was enacted, we had essentially no controls whatsoever. We had a process that is called the MB-10 process, which I described in a petition that I submitted to the Energy Research and Development Administration as a process that was reminiscent of litigation described by Charles Dickens in Bleak House, where there were dusty old files hidden away somewhere, and it was unclear what procedures applied to approval of fuel cycle activities. The standards were extraordinarily difficult to discern. And frankly, the situation was a mess. It was a major impetus to enactment of the NNPA in 1977 and 1978. Congress realized at that point in time that it had to bring U.S. controls over back-end fuel cycles activities by our partners under control. And that was taking place at a time when both President Ford and then President Carter recognized the risks associated particularly with reprocessing and with breeder reactors. So what happened in 1978 was that Congress did enact the Nuclear Non-Proliferation Act. And it's a remarkable law, to my judgment, even when looked back from the perspective of 40 years, in that it was an effort to impose significant restraints on how the executive conducted nuclear cooperation activities with our allies. And a central goal of the NNPA was to ensure that back-end fuel cycle activities took place under conditions which reduced to the maximum extent possible the risks of nuclear proliferation. I won't bore you with a detailed analysis of the language of the statute and its legislative history and structure, but suffice it to say that what Congress was interested in doing, and this is reflected particularly in the legislative history, was establishing what they characterized in the House and Senate reports as clear, unambiguous, and simple rules governing fuel cycle And one of the essential elements of the controls that the United States was imposing, that the United States was have what are called consent rights with respect to fuel cycle activities. And it was contemplated, as far as I'm concerned, by almost everyone involved in the elaboration of the NNPA, that these consent rights were going to be exercised on an iterative basis over the term of our agreements for cooperation with our allies. That is, there's really a tripartite structure to the NNPA. First, agreements for cooperation are entered into, and the law establishes that one of the elements of an agreement for cooperation is the retention of consent rights by the United States. Secondly, the Act contemplates that licensing activities will be undertaken. And if you look at the criteria for licensing, one of the key criteria is that consent be maintained over fuel cycle activities of our partners. And finally, there's a provision of the law, Section 131, which establishes an elaborate procedure for what were called subsequent arrangements. And these were arrangements to approve fuel cycle activities after fuel had been burned in reactors. And there's frankly no doubt in my mind that Congress did not contemplate at that time that these consent rights be exercised in advance for the life of an agreement without regard to issues such as timely warning of diversions. Now, I want to say a word about timely warning because Henry mentioned it. This is the key standard that is embodied in Section 131 of the Act, and I'll read it to you because it's worth reading. Section 131 says that before fuel cycle activities can be approved, before a subsequent arrangement can be approved, the Secretary of Energy has to make a determination that the reprocessing will not result in a significant increase in the risk of proliferation beyond that which exists at the time the approval is requested. Among all the factors in making this judgment, foremost consideration will be given to whether or not the reprocessing will take place under conditions that will ensure timely warning to the United States of any diversion, well in advance of the time at which the non-nuclear weapon state could transform the diverted material into a nuclear explosive device. That's the key standard of the law. To my mind, that's the guts of the NNPA. And it strikes me not only as improbable, but contrary to logic, that you can make a determination that there will be timely warning of diversion, or even there'll be a significant increase in the risk of proliferation 30 years into the future. You simply can't crystal ball those decisions, and in my mind, support it with any rational argument. That, in my view, is what Congress intended in 1978. Well, what happened? What happened was something far different. While the Carter administration exercised a policy of case-by-case review, and in fact, only granted approvals for reprocessing activities when there was demonstrable need, that was the criteria at the time for those activities. The policy was dramatically changed in 1982 in the Reagan administration. And in June of 1982, the Reagan administration announced a policy which basically said, we're now open for business to grant long-term consent to reprocessing in advanced nuclear programs that were well-defined. The first such agreements that embodied these advanced consents were agreements with Sweden and Norway, presumptively uncontroversial. We weren't worried about the Swedish and Norwegian military programs or their threat to the United States. And we gave Sweden and Norway advanced long-term consent to reprocess nuclear fuel from reactors provided by the United States or from fuel provided by the United States, as long as that reprocessing took place in the UK or France. And we retained the right to approve the transfer of the separated plutonium back from the UK and France to Sweden and Norway. Well, even though those were mitigating circumstances, I didn't like it. I felt that that was at odds with the language and history and structure of the Nuclear Non-Proliferation Act. And representing then Senator Alan Cranston and Representatives Howard Volpe and Mike Barnes, we brought a lawsuit termed Cranston versus Reagan.
Guess who won?
Hmm?
Guess who won?
Well, we raised all these issues in great depth in that lawsuit. Unfortunately, from my perspective, the court never reached the issue. The court said, well, this raises a non-justiciable political question. I don't want to get into issues which relate to the validity of our agreements with our allies, and I'm not going to reach the merits of the case, whether these agreements are contrary to the nuclear non-proliferation or not. And that was the end of it. And that case was never appealed, and that stands as the only example of litigation challenging advanced long-term consents. It didn't really get very far. What happened next was Henry referred to the Japan Agreement. That was in 1987 and was presented to the House and Senate in 1988. That went much further than the Swedish and Norwegian agreements. The Japan Agreement basically said the United States was approving fuel cycle activities in Japan for the life of the agreement, even in facilities that had not yet been built. It was an undefined program, contrary to the Reagan policy of 1982. There was no control whatsoever as a practical matter over where and how fissile materials would be reprocessed in Japan. This was a highly controversial agreement, and there was a long debate, particularly in the Senate in March of 1988, about the Japan Agreement. It's worthwhile going back and reading that debate. It's in the congressional record. It's very instructive, and among other things, it includes the report by the General Accounting Office, which calls into question the legality of these arrangements, and sets forth in great detail the arguments of the proponents as well as the proponents of this agreement. One of the things, and I want to underscore this particularly, that the administration did with a timely warning criteria, which is the guts of the determination about whether this arrangement is going to be inimical to common defense and security or result in a significant increase in the risk of proliferation, is that the administration said, well, timely warning, we know some people think this is a technical issue, and by the way, when the act was passed, most of us thought it was basically a technical determination regarding safeguards effectiveness that was going to be involved when timely warning determinations were made. Not so, said the administration. What the administration said in presenting the Japan Agreement was that the following factors all could be taken into account in assessing timely warning. Japan's research, development, and production programs and capabilities, Japan's industrial capabilities, Japan's scientific and technical capabilities, the availability of special nuclear material in Japan, and indicators of diversion-relevant activities. Basically, the whole ball of wax. Economic, social, political factors could be taken into account. And then the administration said, basically, well, trust us. We can make these determinations related to generic factors, political factors, 30 years into the future, without regard to technical effectiveness of safeguards. And sadly, from my perspective, Congress went along. And there was a vote taken in the Senate on March 21st, 1988, that on a resolution of disapproval related to the Japan Agreement, and the vote was 53 senators against the resolution of disapproval, 30 senators for the resolution of disapproval. So the agreement was approved. And that established, to my mind, what is the central precedent that we're operating with today. Basically, the timely warning means the whole ball of wax, and it's perfectly permissible for the United States to authorize our trading partners to engage in fuel cycle activities over the term of an agreement for nuclear cooperation, that is 30 years. The final nail in the coffin, from my perspective, was in 1996. It actually postdated the Japan agreement. That's when we entered into an agreement with Euratom. And the agreement with Euratom goes even further than the Japan agreement. Instead of even nominally retaining consent, and I should say the structure of the Japan agreement said that we will retain consent and then we gave it away in something called an implementing agreement. In the Euratom agreement, we simply said we're authorizing fuel cycle activities, period, for the term of this agreement. And while there are, in principle, avenues for revoking consent, as a practical matter, they're so constrained that they can't be exercised.
1996?
That was 1996. So fast forward to 2019. Where are we today? Well, I think this story is interesting as an academic or historical exercise. I think as a practical matter, the congressional acquiescence in the executive branch's interpretation of the Nuclear Non-Proliferation Act means, as a practical matter, that the administration's or the executive branch's interpretation of the NNPA is not really subject to challenge today, at least in litigation. It's not to say one can't go back to first principles and look at what Congress intended in 1978. But the practical implications of 20 years of very intense effort by the executive branch to provide advance consent for reprocessing activities and to limit U.S. controls is ultimately very effective. And today, in 2019, I think as a practical matter, that's the regime with which we're living.